So, hi everyone. Thanks for joining us this evening. My colleague Kathy and I are looking forward to talking about this topic. I know that it's something that she and I encounter all the time, and it's just an alternative practice management structure that is certainly relevant in these kind of fluctuating financial times. So, So my co-presenter here today is Kathy Nichols. She's a senior healthcare attorney at Carlson Jaya Kumar. She represents hospitals, physicians, licensed healthcare providers, professional corporations. Her practice includes representing clients before the California Medical Board, all the way from investigation through trial. Um, she also counsels medical groups and physicians on corporate employment, healthcare regulatory matters. I've had the pleasure of working alongside Kathy, and I can confidently say that her knowledge and judgment in this arena are second to none. And here's me. I'm Alessa Huber. I'm the co-founder and partner at Cooper and Huber. I work as outside general counsel to healthcare providers, physician groups, healthcare related businesses across California. I represent clients in mergers and acquisitions, strategic affiliations involving medical practices, anything. I guide providers through everything from entity formation to ownership transitions to operational contracts. My goal is to provide practical legal advice and function as kind of a long-term partner for my outside general counsel client. So we wanted to talk today about management services organizations, or MSOs. And before we jump into what an MSO is, I wanted to take a minute to talk about what's really going on in healthcare right now, because that's the why now. Why are physicians and other healthcare related practices looking for alternative models of practice management? And well, the reality is there's a lot of economic uncertainty going on. And I've worked with groups that have been in practice for decades, have never had any sort of financial issues, but in recent years have discovered they're busier than ever, but struggling to make like payroll every month. And that seems to be becoming more and more prevalent for my practice clients. So the economic pressure is real. Reimbursements aren't keeping up with inflation. Medicare rates are stagnant. Commercial payers are denying more claims and taking longer to pay. Even if you're doing everything right, cash flow can be a nightmare. And I work with cash pay practices as well. So you might be thinking, aren't they insulated from this reimbursement chaos? And to some extent, yes. If you're not relying on insurance reimbursements, you can avoid those delays and denials, but they face some of the same skyrocketing costs that all healthcare practitioners and private practices are facing right now. Really, retaining top talent, managing patient expectations, navigating vague regulatory laws, ensuring client experiences matching their experience match the expectation and the pricing. And the truth is, whether you're billing insurance or running a cash model, the administrative burden and the economic uncertainty is unreal. It's real. So I wanted to, I was looking into this and what studies had been done on physician practices and the impact of the economy on the same. And I found that according to the American Medical Association in 2023, just about half of physicians reported experiencing at least one symptom of burnout. And on average, physicians spend 1 to 2 hours of personal time each night, so outside of normal work hours, on administrative related tasks. And I know many physicians who can attest to that being true. They go home, they have to sign charts, review charts. And so all of these challenges point to the same conclusion, which is that physicians need help. They need business infrastructure. They need strategy, freedom from back office burden. And that's where an MSO comes in. So, what exactly is an MSO or a management services organization? Well, an MSO is basically the back office, everything except patient care. It's a legal structure that lets business professionals run the business side of the practice while physicians keep full control over clinical decisions. And I keep saying physicians, but this can apply to really any professional services, healthcare related, occupational therapists, physical therapists, psychologists, medical spas. It can apply across the board. So the Management Services Organization, or the MSO, and the Professional Corp are distinct legal entities, and the MSO essentially partners or collaborates with the professional corporation, which stays owned and controlled by the licensed professional, whether that be the physician or the occupational therapist or the psychologist, to provide administrative and business support. The idea is that the professional corp, the PC, makes all of the clinical calls. It hires, fires, trains clinical professionals. It accepts payment from the patients or commercial payers or Medicare, and then pays out the professional service providers, and then pays separately the management services organization to handle the business admin aspect of the practice. And both Kathy and I have worked on many professional corp MSO relationships. You're probably wondering, what does the MSO actually handle? Well, the MSO can handle as much as or as little as the practice wants. Typically they're handling things like HR, payroll, recruiting, staffing, benefits, personnel issues, billing and revenue cycles, anything that's not within the licensed professional purview. So the MSO does not take over the practice. It brings structure and support so that the physicians can focus on delivering care, training, and supervising other physicians. So this model has become increasingly popular in my practice. I know that Kathy and I are approached all the time about folks that are looking to either engage with an MSO or form an MSO, or have questions about how they can better manage their practice. And this is certainly something for them to consider. So it's become increasingly popular. It offers the support that physicians need while preserving clinical independence. And in the next slide, we'll dive into exactly why the MSO structure is so effective, especially in today's economic and regulatory climate. So why does it work? Well, first, it solves the CPOM issue. So if you're not familiar with CPOM, that stands for the Corporate Practice of Medicine, which in California and federally prohibits non-physicians from owning or controlling a medical practice. But many practices want help from executives or other strategic advisors that have been trained in this area. So the MSO structure makes that possible from a legal perspective because the PC retains its independence and control over clinical decisions. It's also, secondly, it's scalable. So with the MSO handling non-clinical functions, practices can standardize procedures, reduce redundancies, expand to multiple locations more easily. There's also agility. So MSOs will often serve multiple practices, not just one. And that creates bargaining power, right? So think about it. If you're a solo practice trying to negotiate better rates on your EMR system or a medical supplies or even janitorial services, you're one voice in a sea of thousands. But if an MSO is negotiating on behalf of 5, 10, 20 practices, suddenly you're not a small fish anymore and you're a portfolio, which gives you leverage. And so the MSO model allows practices to benefit from the collective efficiencies without giving up clinical independence. And finally, for those looking at long-term growth or eventual scale, MSOs are private equity friendly. So PE firms love a well-structured MSO PC relationship because it gives them operational visibility and legal clarity. So these are some of so now you can see how the MSO solves some real world problems, and it invites business support, scales operations, protects the clinical side, creates long-term value. But for all of that to work, the legal structure has to be airtight, which brings us to the legal framework behind the PC MSO model. And I know that Kathy wanted to chime in here, so I'll let her do that.
Thanks, Alessa. And I think if anyone has any questions, I think you can pop them in the chat or raise your hand. And we're happy, and we'll save a little bit of time when Alessa and I are done if you have any questions. But yes, the legal framework kind of dig deeper on the corporate practice of medicine, which is the legal doctrine that sort of requires that we do this sort of complex structure of a separate MSO entity. Is that doctrine, it prohibits non-licensed individuals from owning or controlling medical decisions. So it all harkens back to medical decision making. And about 30 states do have some version of the corporate practice of medicine. They all vary. Some are just physicians. California is pretty restrictive in that it's basically all licensed healthcare providers have some version of the corporate practice of medicine that limits how their professional corporation can be structured. But the physician probably has the most restrictive, and in most states, the medical practice can only be owned by a physician or a combination with another licensed provider. Those are called multidisciplinary practices. You'll see that with a physician and maybe a nurse practitioner. The physician still has to have a majority interest if it's a medical practice offering full medical services. You can also have a physician assistant owning with like a physical therapist. We've seen that. So there's different combinations. Most of them, go together. Dentists can't really go with too many of the different licensed healthcare providers. But for the most part, you can structure a multidisciplinary practice as long as the key is that you have a licensed healthcare provider with an ownership interest. Medical practice can still employ non-licensed folks, a CFO, a lawyer, things like that. But it's the ownership interest where this doctrine comes in. And so that's why it's critical as we're digging deeper into this, what we call MSO PC structure, which is Management Services Organization, is the entity that does the management services that Alessa was talking about. And the professional corporation is the medical practice. And we say PC because, again, that could be a physical therapy corporation, occupational therapy corporation. They all have the same structure that is required. And so the PC remains responsible for all clinical decision-making. The MSO handles the business operations, and cannot influence the clinical decision making. So there is, I don't want to say it's a gray area, but it's a complex area of law because it's very dependent on what type of practice is structured. But medical decision making is, as physicians know, is not a bright line rule, and it's going to depend on the scope of practice. And so the corporate practice of medicine is a combination of corporate laws as well as the Medical Practice Act or whichever nursing act, Physicians Assistants Act, whatever license that you have, that act is going to govern that, and all those boards enforce it differently. But the key is that we're maintaining clear boundaries. As it indicates there, we want safeguards to ensure that the MSO doesn't interfere with the clinical decision making. and making sure that the MSO is supportive and not controlling. And then there's various degrees of support that an MSO can do. And but the key is that these are separate entities that work together, as Alessa said in the beginning, to make the entire operation of the practice more efficient, which is what our overall goal is on this. So I think the next slide. Okay. And so in terms of the PC formation and physician ownership, as mentioned, it does need to be owned and controlled by physicians, and the MSO cannot have any ownership in those shares. All the shares of the medical practice would have to be owned by licensed professionals. And I often get questions, especially in the Medi-Spa space, where a physician is approached by, let's say, a nurse who says, we want to open up this medical practice. We want you to be the majority owner. Don't worry, we're just going to give you a monthly stipend. You're just the owner on paper. You don't really have any responsibilities. That's not compliant. A medical spa is a medical practice in California, as with many states. If you need a physician to perform medical services, then it needs to be structured as a medical practice. And so that is a sort of a red flag if you're approached by another licensee or an MSO saying, an MSO owner saying, hey, we want to start this medical spa. Can we bring you in? We'll fund the whole thing. You'll just be the doctor on paper. I had a client one time that they didn't know the address of the medical practice they owned. And unfortunately, they were in a medical board investigation over that. So it's really critical, and that's why we want to get the word out that you just have to do the structure correctly at the beginning. And if you think about, it's kind of hard to remember corporate practice of medicine. It's kind of a mouthful, but the key thing to think about is medical decision-making is done by physicians. So who to hire, what services to offer, all of that is within the purview of physician. The MSO can support, the MSO can recommend, but at the end of the day, the physician needs to make that call. And so part of the compliance piece, so like I said, we want to make sure you have a sound foundation for the practice, is having these key agreements in place. And the management services agreement, if you've heard that term, sometimes it's referred to as an MSA. This is the critical document. When Alessa mentioned that we work together on a lot of these, we spend most our time preparing the management services agreement because this is the key document that describes the services that the MSO will provide to the medical practice. And the reason why that is so important is that if we just have an MSO being paid for providing medical services by a medical practice and you don't have an agreement describing what they're doing, the legal assumption is that it's fee splitting and that it's, a fee for a referral, paying for patient referrals, which are both illegal. So to remedy that, we have an agreement that describes all of the service, the scope of the authority of the MSO. And like I mentioned earlier, there's varying degrees of how much the MSO can do. There's some that we structure where the MSO does a tremendous amount of services. Again, not doing the medical services, but has a tremendous amount of administrative HR support, and they have a lot of operational know-how that they're bringing to the practice. Others are a little bit more scaled back. Again, it's very dependent on the type of practice, the size of the practice, and again, the size of the MSO and what the MSO is providing. But that management services agreement is critical to being compliant. And then the other agreements that usually you'll have alongside of that is, a space or a lease agreement, equipment lease, software licensing agreements, business associate agreements for HIPAA compliance, non-disclosure agreements, loans, marketing agreements. So there's all types of agreements that can be between these two entities, but the management services agreement is that key document that will ensure compliance for this structure, as long as we've got the entities set up correctly, but assuming you've got that all going forward, then this management service agreement is pretty critical. And so the success of this model depends not only what services are offered, but how they're structured and how they're documented. And so I think we'll go on the next slide and kind of break that down a little bit further for you.
Sure. So, Kathy, just one thing I wanted to add.
Sure.
It occurred to me now because I know that I'm sure you get this question a ton, and I do as well. Under the second bullet point here, MSO ownership can include non-physicians. It's also another way that, in the Medi Spa context, I'm often approached by a nurse or a physician who's, interested in forming this medical spa, and the nurse practitioner, the nurse, is doing a lot of work on the back end to run the business and the marketing and what have you, where the physician is kind of just focusing on the medical care being provided. Well, that nurse can have an ownership interest in the MSO. So it's another way to allow the other people that are involved in making the practice successful
Right.
earn additional income. And, obviously there are considerations there we have to be mindful of, self-referral problems, what have you, but that's why you have good healthcare lawyers to help you navigate those problems.
Yeah, thanks. That's a great point. In terms of, especially in the Medi Spa or concierge model, or any kind of PPO or cash practice, is when you have the multidisciplinary practice where you have the physician, again, has to be a 51 majority owner, 51%, 49 is the max that you could give in your scenario, the nurse or PA or NP. And so in that context, the MSO vehicles, what I'll call it, is you could have an ownership interest, give the minority owner an interest in the MSO, and then as we'll get to very quickly, the fee structure is where, how does the MSO get money from the medical practice, right? We haven't talked about that yet. So on these kind of do's and don'ts, the management fee, again, I said the agreement was critical. The management fee structure is also critical. That goes in the, has to be described in the management services agreement. And so this is the compensation that the medical practice pays to the MSO for the management services. And so that has to be consistent with fair market value, and tied to the actual services provided. So we can't have a real low service and then they're getting a really out of the ballpark type of fee and vice versa. And so the fee structure is dependent. If you've got any Medicare or federal payers, there's going to be some more restrictions so that you stay in the safe harbor for anti-kickback and Stark, which we'll talk about in a little bit. And the other models for the fee is just a fixed monthly fee. And then the other one that we've seen a lot of more often is the cost plus model, which is the costs of the operations that the management company is doing, and then there's a percentage on top of that. So the main key thing to remember again is the management services organization, the MSO, is providing management services and can't do any medical services. So by that logic, the medical practice has to employ all of the healthcare practitioners. So those salaries, which tends to be the largest expense of a medical practice, has to go through the practice, but usually mostly everything else can go through the management company. And again, because the management company is doing that service for the medical practice turns around every month and pays a fee to the management company. So hopefully that explains how, in Alessa's example, the nurse, who's a minority owner of a medical practice, could also share in the revenue by being an owner, either 100% or some percentage of an MSO that is doing services for that practice. Compliant ownership structure, we talked about that. Again, making sure we've got a physician owner or other licensed healthcare professional, not just on paper, they're actually doing it, they're following corporate formalities. And then the agreement requirements, again, having that management services agreement in place, it's not something you throw together. They really have to be, they're usually long-term agreements. 1 year is the minimum that you can have that type of agreement, but often you want to structure it so you have, the goal is a long-term relationship with an MSO and a PC. Um, this isn't, it doesn't need to be approved by any regulatory body, but we want to have a compliant structure in place and a compliant agreement in place because through patient complaints, audits, different regulators can investigate things. And because this is all, we're talking about federal law and state law, there's lots of ways this can crop up into being under having a regulator look at it. So we do want to make sure we're compliant. And then the don'ts, the improper fee splitting, again, that would be where you're just paying the MSO, but you don't have any description of what you're paying for. And so again, the fallback is, well, then you're just splitting fees with a non-physician. That's illegal. Overreaching MSO control. So this would be where the MSO is controlling. I don't want to just say medical decision making because that makes it sound too simplistic, but it's where the MSO is controlling so much of the business of the medical practice that the physician doesn't have autonomy to practice. So we'll see things where there's restrictions on, divestment of the shares of the medical practice or who a subsequent owner can be. And so it can get a little bit complex. There's different scenarios that you can put together, but overall, we want to make sure that the MSO is not directing how the medical practice is practicing medicine or whichever licensed healthcare you're doing. The regulatory risks, Stark, anti-kickback, those are both federal laws. There's also a state law version of the same. And again, this kind of goes back to like what I was saying with the fee, the management fee and the management services agreement. Both of those components are regulated by federal and state law. And so and it's critical to make sure that those risks are vetted because non-compliance with the structure or with the agreement taints all of the claims that you're sending to Medicare to be paid or to the insurance company. The cash business is a little bit different. The risks is a little bit different, but for the most part, an improper structure or an improper management services agreement kind of exposes all of the services to liability for being in a non-compliant structure. So now that we've talked about what MSOs are and how to set them up correctly, we're going to look at some real world applications and how to avoid pitfalls. So Alessa, I don't know if you want to take a couple and I can take a couple or.
Sure. So, I think you touched on some of this already, but I was thinking earlier about the different MSOs that I've worked with, right? And the relationship that we've arranged between the MSO and the professional entity, and some of the issues that we've seen play out.
Mhm.
And I think the one that it always comes back to pay and to the flow of money. And so I have this conversation with clients a lot about how the money needs to flow in a very specific way. The patient or the insurance company has to pay the professional entity. The professional entity pays the clinicians, um, and then pays the MSO for the services that it's providing. So I feel like, real world applications, something that's asked to me all the time is like, if I'm a physician and I'm the owner of a professional corp and I really just want to focus on practicing medicine, I don't want to have to think about all this back office stuff. I don't want to deal with that. How can I legally give the MSO the reins so that they can pay all my bills and that they have access to the money to be able to pay the expenses, but we still have that flow of money and things are legally compliant? So, that comes up a fair amount in my practice anyways. And I have to, there are different safeguards that we can build into the management services agreement that, allow there have to be separate bank accounts. Maybe the
Mhm.
MSO is allowed to access that bank account for payment of certain expenses. But again, this is why it's so important to have that compliant management services agreement, because these real life issues that show up of like, hey, I'm the doctor, I don't want to be bothered with like writing a check to pay for this vendor. So, but how do we keep the flow of money appropriate? So That's just something I was thinking about earlier today that has come up with a couple different clients.
Yeah, no, that's a really good point. And something that I think is also relevant is, even if if you're listening to this and you're like, well, I'm not 100% compliant, that's something that can be fixed. It's usually I get someone coming in the door who's just clean slate. We're starting from the beginning, and that's usually very straightforward. But the other half of the time, it's a practice or an MSO that's been operating for a long time, and they're just not compliant. And luckily, for the most part, haven't had any issues. But it's something that can be revised, can be fixed. We've fixed corporate structures before. Um, we have here a couple of things on the third bullet point, growth strategy, with multi-location franchising and private equity prep. I think for the franchising, healthcare franchising is pretty popular. But it almost always uses the MSO PC model because a franchisor, which is like the main owner of a franchise, um, doing a franchise directly with a physician or any kind of healthcare practice, it's almost impossible with the corporate practice of medicine because the franchisor has to have so much control. So to sort of break that up, if you will, this structure, we call it the MSO PC structure, is really, I would say, like a tried and true across the country because franchises typically tend to be um, national. So that's one idea, one thought. And then the private equity prep, having this structure in place, and I'll say a compliant structure in place, really makes you more attractive if that's the avenue that you're going towards. And I did have a medical practice client that was not set up correctly, the corporation, and they didn't have an MSO. And they were approached by a PE firm for a very lucrative deal that because of these problems with the corporate structure and the lack of MSO, it really sort of just fell apart because they didn't have those critical things in place. So it is very important. So I think these these key takeaways are important because what we're trying to, I think, get across with this presentation is, with economic uncertainty, the MSO PC model is something that potentially could be very attractive for a medical practice to like scale efficiency, and to sort of uh, make you ready for long-term investment if that's what you're looking towards. Um,
Yeah. And it can kind of help weather some of the issues with the economy too, right? Because if you have an MSO, like I was saying earlier, that has 20 different practices that it's working for, that they're going to have more leverage in negotiation, get better rates, things like that. So it's
correct.
definitely something to consider for some of these private practices.
Yeah. So
Right.
um,
I don't thank you, Kathy and Alessa. That
yeah.
was so informative and went so quickly. I was like so engaged. I couldn't believe that the time went so fast because there's a lot of great learning here for me as well. I don't see questions in the chat, but if anyone would like to ask a question, please raise your hand. And while people are thinking about their questions, you can raise your hand and come off chat, or you can put something in the chat. And it looks like we have something here. Can the MSO collect funds on behalf of the PC?
Yeah. So I think, sorry,
Sorry.
we're both talking at once, but
Go for it.
yeah, I think it depends what you mean by collecting funds. So the MSO can function as a business administrator would, right? So if you have an MSO that is handling the collections of from insurance companies, from patients, from whoever, of course, yeah, they can absolutely handle that. But again, the flow of money is so important, right? So those funds, the MSO can facilitate the collection of the funds,
Mhm.
but the funds are not going into the MSO's bank account. They're going into the professional corporation's bank account.
Right. Yeah. And a lot of times, um, some insurance companies, it's not really a Medicare issue because the corporate practice of medicine is a state thing. So Medicare will pay whoever, I can go get an NPI if I want and they can pay me. I would later get in trouble for healthcare fraud, but I'm just saying they could technically pay, right? The federal law does not care what type of structure it is. It's a California specific thing, but you can run into insurance companies saying, what's this management company, and they don't have an NPI and the MSOs and employing the providers. So it can get a little messy, but I think what the question is getting at is, like Alessa said, the MSO can do all the work to get the claims paid, to get the patients to pay if it's cash practice. And then the banking, again, separate bank accounts, but the MSO can have power of attorney over the practices account. It can have there's a lot of leeway. It kind of overall depends on the entirety. My view is the entirety of the management services agreement. So if you really want to have a lot of control over the banking and the way the money flows and having like accounts swept from the PC to the MSO, we just have to make sure there's not too many aggressive parts of the other agreement. All attorneys kind of do it a little bit differently, but that's kind of my view is you have a lot of freedom because I think I know what the question is getting at, is that the MSO can really do a lot of the legwork and controlling a lot of the money flow, but the PC ultimately is the one that's bringing in the revenue for the medical services. That's the main key distinction. A great question.
Great question indeed. I have a question. So if private equity does come in, how does that relate to the relationship of the PC and MSO? So does it become a third entity? Does it take the place of the MSO? Does it take over the MSO? What have you seen, and how does that work potentially?
Yeah, I'll tell you, my experience has been it's always going to be the MSO side because the PE, there's no physicians in private equity. I mean, there might be, but you need 100%. You don't have 100%. So it's going to be the MSO they're going to have an interest in that. And then sometimes they have their own MSO. And so then it'll just transition, like the practice stays in place and then they just are ending that relationship. It kind of depends on what relationships the MSO, and Alessa chime in, like if there's a bunch of vendor relationships like that the MSO has that are really valuable, so it's very like, I think case specific. That's been my experience.
Yeah. And right. So same here. Private equity is looking at the MSO. They can't buy the professional corporation, but they can purchase the MSO, which then has all these relationships with professional entities and is providing the service, or they can invest in that MSO. So that's where their focus is. But yeah, that's what I've seen as well.